Welcome once again to Lehto's Law. Here's Steve Lehto.
Josh tipped me off to a story. I've been following this one through the news, but apparently it just made the Supreme Court, so this is important. It's a First Amendment case. And First Amendment cases are interesting because we know that the First Amendment, among other things, is the right of free speech. And many people misunderstand that, however. And so I'll get comments, for instance, where people will say, Steve, if someone makes a rude comment to one of your videos and you delete it or someone deletes it, that is censorship. And it's a violation of the First Amendment. And it's not a violation of the First Amendment because the First Amendment actually prohibits the government from stifling your speech. Doesn't talk about private parties or private entities. So if the government stifles your speech, yeah, violation of the First Amendment can be. But a private entity, no. So that's an important distinction to keep there. But the other thing is that when you go through law school and you study the constitutional law, they talk about the First Amendment. And the cases start out a long, long time ago, primarily with things that people are saying or that they're printing, right? Printing presses have been around for a long time, so newspapers and so on. But as technology has changed, you start getting into things like, what about things that people say on the radio? What about things that they say on television? And of course, now it's what about things they say on the internet? So it's a sign of the times. Adam Liptak wrote this. It was a Saturday in the spring of 2017, and a ninth grade student in Pennsylvania was having a bad day. Just found out she didn't make varsity. She's a cheerleader. She's going to get stuck on that junior varsity squad for one more season, if you can believe that. So she expressed her frustration on social media, sending a message on Snapchat to 250 friends. The message included an image of her and a friend with their middle fingers raised, along with the text expressing a similar sentiment. Using a curse word 4 times, the student expressed her dissatisfaction with school, softball, cheer, and everything. Hey, we've all been there. Though Snapchat messages are ephemeral by design, another student took a screenshot of this one and showed it to her mother, who is a coach. The school suspended the student from cheerleading for a year, saying the punishment was needed to avoid chaos and maintain the team-like environment. Now, the student sued the school district and won that case. And then in the United States Court of Appeals for the Third Circuit in Philadelphia, she won again. The court said that First Amendment did not allow public schools to punish students for speech outside of school grounds. So she wasn't at school when she made the post. She was someplace else. The Supreme Court agreed to hear the case this past week. The Third Circuit's ruling is in tension, as we say, with decisions from several other courts, and such splits often do get the Supreme Court to step in and review it. So there are different circuits of appeal, and some have apparently come down to the other side on this. And I'll talk to you about the other case I know a little bit about involving high schools and free speech. But the school district said administrators around the nation want a definitive ruling from the Supreme Court on what power they have to discipline students for what they say away from school. The question presented recurs constantly and has become even more urgent as COVID-19 has forced schools to operate online. That's from the brief that the school district filed. Only this court can resolve this threshold First Amendment question, bedeviling the nation's nearly 100,000 public schools. The law professor at Yale named Justin Driver, who wrote a book called The Schoolhouse Gate: Public Education, the Supreme Court and the Battle for the American Mind, agreed with the school district to a point. It is difficult to exaggerate the stakes of this question, but he added that schools had no business telling students what they could say when they were not in school. In the modern era, a tremendous percentage of minor speech occurs off campus but online. Judicial decisions that permit schools to regulate off-campus speech that criticizes public schools go against the First Amendment. Such decisions empower schools to reach into any student's home and declare critical statements verboten, something that should deeply alarm all Americans, especially the use of the word verboten in that statement. The key precedent is from a different era because it was 1969 in a case called Tinker. The Supreme Court allowed students to wear black armbands to protest the Vietnam War, but said that disruptive speech on school grounds could be punished. Making distinctions between what students say on campus and off was easier in 1969 before the rise of social media. These days, most courts have allowed public schools to discipline students for social media posts so long as they are linked to school activities and threaten to disrupt them. But a divided 3-judge panel of the Third Circuit took a different approach, announcing a categorical rule that would seem to limit the ability of public schools to address many kinds of disturbing speech by students on social media, including racist threats and cyberbullying. And one of the things that someone I'm sure is going to point out is that if you're at home in your bedroom and you're listening to that rock and roll and discussing the varsity versus junior varsity cheerleading squads, and you make a post on social media, that the next day at school is when a lot of kids are going to see it, because they're going to be at school and someone's going to go, hey, did you see the post that she put up? I'm not friends with her. Oh, hang on, I'll send it to you. And so there will be disruption at school caused by these posts, but the posts are being made off school grounds, not during school hours, right? So in a concurring opinion, a judge wrote that he would have ruled for the student on narrower grounds. It would have been enough, he said, to say that her speech was protected by the First Amendment because it did not disrupt school activities. And he said the majority was wrong to protect all off-campus speech. In a brief urging the Supreme Court to hear the school district's appeal, the School Boards Association said the line the Third Circuit had drawn was too crude. Whether a disruptive or harmful tweet is sent from the school cafeteria or after the student has crossed the street on her walk home, it has the same impact. The Third Circuit's formalistic rule renders schools powerless whenever a hateful message is launched from off campus. So that's an interesting point. School lets out at 2:30. Student walks across the street and at 2:31 types something vile. How different is that if they had sent the exact same post at 2:29 on the other side of the street? So then again, the law often contains rules and definitions like that. So we'll see. The student, of course, is represented by the ACLU, told the Supreme Court that the First Amendment protected her colorful expression of frustration made in an ephemeral Snapchat on her personal social media on a weekend off campus, containing no threats or harassment, didn't mention the school, and did not cause or threaten any disruption of her school. Good point. The brief focused on that last point, did not spend much time defending the Third Circuit's broader approach. The Supreme Court has a reputation for being very protective of First Amendment rights. Chief Justice Roberts, in an appearance at a law school last year, described himself as probably the most aggressive defender of the First Amendment on the court right now. But the court has been methodically cutting back on students' First Amendment rights since the Tinker decision in '69. In the court's last major decision, which was 2007, Roberts wrote the majority opinion, siding with a principal who had suspended a student for displaying a banner that said, "Bong Hits for Jesus." And that's the case I was going to mention. I said I know a little bit more about this case. A friend of mine actually worked on this case. He's an attorney, but he's a guy I went to high school with named John. And John now is in Alaska, where he does a lot of school law. And he mentioned this to me a while back. He said, "Hey, Steve, I just had a case that went to the Supreme Court." And I said, "Really? Did you get to argue?" And he said, "No." But he got to work on the lower level, appeals of that case. And then when it went to the U.S. Supreme Court, they brought in some heavy hitters who specialize in arguing before the Supreme Court. But that case, often referred to as the Bong Hits for Jesus case, is Morris versus Frederick. And I'm going to give you a synopsis. The court ruled 5-4 that the First Amendment does not prevent educators from suppressing student speech that is reasonably viewed as promoting illegal drug use. And in that case, in 2002, Juneau Douglas High School principal suspended a man after he displayed a banner reading "Bong Hits for Jesus" across the street from the school during the Winter Olympics torch relay of 2002. He then sued, claiming his constitutional rights to free speech were violated. His suit was dismissed by the federal district court, but on appeal, the Ninth Circuit reversed the ruling, concluding that his free speech rights were in fact violated, and then it went to the U.S. Supreme Court. Roberts wrote for the majority, concluded that the school officials did not violate the First Amendment because to do so, he made three legal determinations. First, that school speech doctrine should apply because this speech occurred at a school event. Second, the speech was reasonably viewed as promoting illegal drug use. And third, a principal may legally restrict that speech based on the three existing First Amendment school speech precedents and other constitutional jurisprudence relating to schools and a school's important, indeed perhaps compelling interest in deterring drug use. So the interesting thing about the Morse case is that it was specifically addressing someone talking about drugs. And the question, of course, is what did Bong Hits for Jesus mean? Did it mean anything? Or was it just nonsensical? I don't know. But the Supreme Court said the school could actually prohibit that kind of speech and get away with it. Of course, it went to the U.S. Supreme Court to get that far. So now the question is, this cheerleader is not promoting any illegal activities. She is simply expressing a harsh opinion using what most people would consider to be a vulgar symbol along with some vulgar language. And that is a different question. So it'll be interesting to see how they rule on this. Don't be surprised if we get another 5-4 out of this, but we'll see. And by 5-4, I mean it's going to be a close decision. I doubt there'll be a landslide one way or the other on this one. But there is something else that I have to point out simply because they often refer to attorneys as attorney and counselor, right? Attorney and counselor. So an attorney can advise you on the law and what you may or may not do here, what you should or should not do here, give you strategy, advice, things like that. Counselor means that occasionally we can step outside of the actual legal aspects and point out other things that occur to us that are relevant. And sometimes it's simply because, having been around the block more than once on this, we've actually discovered other things that pertain to this that might just be common sense. So, for example, if you are a parent and you have a child at school and you're trying to think, is there something we can learn from this I could tell my kid about? And, you might not want to tell your kid, hey, by the way, the Supreme Court might say you're allowed to say anything you want about school as long as you do it off school grounds. But more importantly is that screen grab of the cheerleader expressing her frustration. I don't know how much it will affect her in later life because she's about to become famous regardless because she's got a Supreme Court case that's going to be named after her, I suspect. But I've had people talking to me about their children, their adult children. And I've had someone tell me, they say, oh, by the way, my kid's got a Snapchat or an Instagram or a this or that. And they've got X number of followers and there's a big, big presence on the social media as they're in high school or in college. And I've actually gone and looked at a few of these social media posts that their kids have done and seen some things that I was like, wow, I'm kind of surprised that the parents are cool with that. Because the parent told me about the page. I went and looked at it. So I assume that the parent's seen the same thing I'm looking at. But see, I'm not looking at it like I'm their parent. I'm looking at it like I'm just another person in the adult community. And interestingly, what you have to ask yourself, the same way that you often tell business clients that when you're writing an important email and you're asking yourself, is this email written correctly? Ask yourself if it was blown up this big and on poster board in front of a jury. Would there be anything you'd want to change right now while you have the chance? And suddenly people go, oh, wait, yeah, hang on a second. Because it might be Exhibit A in a lawsuit, right, if it's an important email. And so I always tell people if they ask, when you're looking at your social media and you're getting a kick out of how many likes you got, how many thumbs ups and whatnot, smiley emojis, ask yourself if you're sitting at a job interview for your dream job and the person interviewing you goes, oh, by the way, you have an Instagram account? Are you going to be mortified or proud of what they see? Because more and more these days, employers do look at social media presence. Now, there's some jobs that social media is all it is. And if you're going to go doing PR for somebody who's a social media influencer, they might be impressed with what you got on your Instagram. But if you're going to work at a firm with people who are a little bit older, a little bit more old school, and the firm has got a real conservative online presence, that person behind the desk on the other side of you might not be so impressed with the photographs that you posted from spring break in Tulum. But the laws are different down there. Yeah, I was gathering that from the photographs. So That's what you need to think about with respect to your social media. But this is a case that will be heard by the U.S. Supreme Court. I'm sure it'll be in the news when it comes down, and I'll do a follow-up. But right now, a cheerleader's vulgar message is prompting a First Amendment showdown in D.C. at the Supreme Court. Adam Liptak wrote it. Josh sent it to me. New York Times published it. Thanks a lot. Questions or comments, do put them below. Otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. My mind is going a mile an hour.